So, dear learners, today in this lecture we are going to discuss what is called the evolution of the concept of human rights, Magna Carta to the International Bill of Rights. As we discussed in the previous lecture, that while dealing with the nature of human rights, that human rights discourse that we are seeing that is dynamic, and the catalog of human rights is expanding with the changing needs and circumstances. So, therefore, the evolution of the concept of human rights becomes important for all of us. As we know, the human rights are evolutionary in nature and they have evolved over the centuries. It means that it was not drafted somewhere by some people sat and then they drafted and that became human rights. It is the result of the long struggle of the people for centuries. So that is why human rights are evolved over the centuries. We should also remember that human rights have existed in all societies in some form since time immemorial. So, when we are talking about human rights, you'll find all the societies of the world, all the civilizations of the world, they have some kind of tradition of human rights. They were not called human rights, of course, but human rights or the duties were mentioned in different religious traditions, civilizational values, or you'll find political ideologies, they were mentioned. The catalog of human rights is expanding with the passage of time as new movements for recognition of different dimensions of rights belonging to individuals and groups under changing circumstances are becoming stronger. So, the ever expanding nature of the catalog of human rights we have to understand. For example, you'll find that in the very beginning, when the people were not having any rights to elect their government, so ultimately, at that time, you will find that the absolutist monarchy was there. And the words of the kings were the laws. So at that time, people were not in a position to claim rights. So that's why they started challenging the absolute or authoritarian power of the kings. After that, you will find that the religious authorities, the papacy was also responsible for controlling the wish of the people, at the same time putting restriction on the liberty and freedom of the people. So that is why people revolted against the church as well. You will find feudal lords were responsible for violating the rights of the people. So that is why the feudalism was, that was condemned, denounced, and the people fought against the exploitation of the feudal lords that have been there all over the world. Similarly, when human rights were given, especially the political rights were accorded to the people, and the people got the right. In the beginning, not all the people have got the had got the right to elect their government. Means all the people were not voters. Slowly and gradually, you'll find first of all property qualification, or the people coming from a particular clan, tribe, etc., royal blood. They were given this kind of chance. Then other criteria was also there for qualifying to become a voter. But later on, you will find universal adult franchise was demanded. Earlier, you will find before 20th century, voting right to women was not available. So the women were given voting right only in the 20th century in most of the countries of the world. So it means that you will find that the human rights have been expanding, and they have, the catalog of human rights is adding more and more rights according to the challenges and the circumstances the people are facing and they are demanding. We should also remember that earlier civil and political rights were emphasized, then you will find economic, social, and cultural rights were emphasized, then you will find that the group rights were emphasized, and after that, you will find these days we are talking about the rights of sexual minorities. We are talking about the rights of right to clean environment. We are also talking about right to access internet, etc. All these rights have evolved, for centuries, and whatever we have got today as the human rights, they are the result of a long struggle. While navigating into the evolution of human rights, we find two kinds of human rights traditions. Number one is the duty based traditions, and the number two is rights based traditions. This is also about the Western and non Western perspectives of human rights that we'll be dealing with in the next class. But here, what we have to understand that it is said that the non Western traditions, like Indian, Chinese, and Islamic traditions, are mainly duty based traditions. They are duty based traditions. It means under these traditions, human rights are sought to be protected by relying on due performance of duties by each individual. So it means if everybody is performing his or her duty, then naturally the rights of all people will be realized. That has been the spirit. So that is why for example, the faith-based traditions, they impose duties upon the individuals or the followers that they should follow this kind of path, ultimately not to harm others, practice tolerance, be good to your neighbor. All these duties, be kind to children, be kind to women, all these. So if these duties are being imposed, it means in the light of these duties you'll find that rights are inherent in those duties. Because for example, if I am performing my duty, then others are also supposed to perform their duties. So under this kind of circumstances, what happens that without having a clear cut catalog of rights, when the duty bound traditions are there or the duty based traditions are there, they are also able to protect the rights of individuals and the groups. For example, karma yoga, for example, performance of one's duties selflessly, and dharma in Hindu tradition. Similarly, hukukul abad, the duty toward humanity, and the right, that is the rights of every soul on another, and hukukullah, that is the duty toward Allah, duty towards Almighty. You know, so it means that duties are there, in these traditions, and these duties are protecting rights. Again, in Buddhist tradition, duties based on ahimsa, tolerance, equality, and respect for all human beings, and human dignity is emphasized. So that is why we can say that on the basis of these, that human rights have been there in all traditions. For example, Indian tradition, that is Hindu, Buddhist, and all other traditions, of course, Sikh traditions, or you'll find Jain traditions. You'll find Chinese civilization, for example. You'll find African civilization, for example. Again, you'll find in the Islamic tradition, for example, there are human rights, but these traditions are most of the time regarded as duty based tradition, where the duties are emphasized, and on the basis of those duties, the human rights can be protected. But at the same time, you should remember, it doesn't mean that in these traditions the rights are not there. What happens that in these traditions, what has been tried, there you will find a perfect balance of rights and duties, and that is why it is said that the rights and duties go together. If we claim rights without performing our duties, if we claim rights without caring for the rights of others, it means that it will be a hollow claim, it will be a shallow claim, and this claim cannot be defended on morally respectable ground. So this is the reason that you will find the rights and duties go together. On the other hand, the Western perspective of human rights is mainly rights based, or to a great extent rights centric perspective. Liberty and rights of individuals are emphasized in these traditions. So that is why when we are trying to explore the evolution of the concept of human rights, we will find that from Magna Carta to the American Bill of Rights, or to French Revolution or the Glorious Revolution of England, you will find that rights are being emphasized. Again, you will find in the Marxist revolution, rights are being emphasized. So that is why it is said that the liberty and the rights of individuals are mostly emphasized in these traditions. So that is why you will find human rights and liberties, they overlap. And human rights movements are also called civil liberties movement in these countries. Although human rights have been present in all traditions, ancient civilizations and religious traditions. They started to acquire a dominant place in public space and policies, mainly in the Western political and intellectual discourse during the medieval period. That is again a very, very important point, that human rights were there in all traditions. There is no doubt in it, whether they were duty based or the rights based. But at the same time, what we should remember, that the concretization of human rights that took place in Europe, whatever human right that we have today, the catalog of human rights today that we have, it basically developed in Europe, or in the West, Europe and America. So that is where the Western tradition of human rights has contributed to the contemporary catalog of human rights. During the medieval period, as we all know, that there were reactionary institutions like monarchy, the absolutist monarchy was there. We also find that there was papacy or the church. On the other hand, feudalism or the feudal lords, they were there. So they were responsible for violating the rights of the people, restricting the freedom of the people. And we find that freedom or the liberty is the innate desire of all human beings. So that is why the people were demanding liberty, freedom, and all the great movements, they were built up on the demands for liberty and freedom. Therefore, we will keep up we will take up the evolution of the concept of human rights from the Magna Carta to the International Bill of Rights. Considering this point, that the today's discourse of human rights, or the today's catalog of human rights that we are having today, they are the result of the contribution from the Western philosophers, thinkers, movements, and the revolution. So that is why we are going to discuss the evolution of the concept of human rights in the Western tradition. So, one of the significant milestones is, of course, Magna Carta of 1215, Magna Carta of England, that was, you know, recorded in 1215. If we see Magna Carta, it was an attempt by the British nobility and clergy to restrict the absolute power of the British monarch. So the absolutist power or the authoritarian power that was enjoyed by the British monarch, that was opposed by the nobility and the clergy. Of course, masses did not participate. It was clergy and nobility that was demanding certain concessions, recognition of their certain rights or the claims. So that was what Magna Carta emphasized. It is said that it was the first written document, which consists of 63 clauses, laying down the principle that the king and his government was not above law. As I told you earlier, that the absolute monarchy, what used to happen in the absolute monarchy is that the words of the kings were the law, and there was not rule of law. Rather, of the rule of monarch or the rule of the emperor or the rule of the king was there. So that is, the people did not have any right against the king. People did not have any right against the state at that time. So this was the reason that it was Magna Carta is regarded as the first written document laying down the principle that king and his government was not above law. In the Magna Carta, you will also find that no new taxes could be imposed without the consent of a common council. Earlier, arbitrary taxes were imposed by the king. But now what happens, that the nobility and the clergy or the barons, they forced the king to accept that no new taxes could be imposed without the consent of a common council. It was also emphasized that all free men were given the right to a free trial with a jury. Free trial where they were having the right to defend themselves. Earlier, the king used to pronounce the judgment, or the king officers used to pronounce the judgment, and there was no appeal against it. Now they wanted that there should be a jury, and that was accepted by the king. So that is why, on the basis of this, it is regarded as one of the most important milestones in the journey of human rights. However, about Magna Carta, Professor Vijapur, who has written a very good book on the human rights, that the title of the book is Human Rights in International Relations, and I will suggest my learners to read this book. It has been published by Mana Publication, New Delhi. It is one of the best books that I came across on the topic understanding human rights, and that is quite useful for the learners. So, Professor Vijapur says that the Magna Carta is erroneously called the first instrument of the liberties of English citizens. In reality, it was merely a compromise on the distribution of powers between the king and his nobles. According to him, it gave certain concessions, not rights as we understand them today. This is the comment or this is the criticism of Magna Carta, that it is overestimated. And while overestimating, we say that it is a significant document. However, it did not recognize the rights as we have today. Rather, certain concessions were given, that too not to all the people, but to the nobility and the clergy or the barons. Nonetheless, the significance of Magna Carta in restricting the absolute powers of the monarch at that time cannot be underestimated. The absolute power of the monarch were challenged at that time. King John accepted the demand of the people. You can understand what kind of pressure the clergy and the nobility would have mounted on the king, because kings at that time were not ready to compromise with their powers. But under what kind of circumstances were developed because of the these demands that King John accepted, and the nobility was motivated to demand governance reforms and fix the king's accountability. This is the beginning of the accountable government. So that is why you know Magna Carta cannot be underestimated. We should not forget that kings used to claim divine rights and powers to rule at that time, as the divine origin theory of a state was in vogue. You see, during the medieval period, especially during the Dark Age, it was the divine origin theory of a state that was in vogue. It means that this theory emphasized that a state is created by God, ruler is also appointed by God, the acts of ruler are the acts of God, and if the people tried to disobey the orders of the king, it means they were disobeying God. It was just like a blasphemy. So at that time, when the king used to claim divine rights, divine power to rule over the people, and the actions of the kings were not questioned at all, rather it was a blasphemy to question the authority and the power and the prestige of the king. So under those kind of circumstances, if the barons, nobility, the clergy was able to force King John to sign Magna Carta, so that was a big achievement indeed. After Magna Carta, another important event in the history of England was the Glorious Revolution of 1688. In fact, what happened during the Glorious Revolution, we should remember that before Glorious Revolution, there was already civil war in England. And this civil war in England was such in which you'll find Charles I was beheaded. The king who used to claim divine right, divine power, he was killed, he was beheaded, he was defeated by the people. So that is why, and that was in 1649, 58 at that time. From there, you'll find Civil War of England, if you see 1649 to 60. Then in 1688, what happens? That we should try to understand, and why it is called Glorious Revolution. First of all, we should remember that it is called Glorious Revolution because not even a single drop of blood was shed in this revolution. So that is why it was called, it was a bloodless revolution, so that is why it is called Glorious Revolution. What happened there, that the conflict between the king and parliament forced James II to abdicate the throne in 1688. The conflict was already there. In the 17th century, you'll find that upheavals were there in most parts of Europe, especially in England, and that's why the commoners or the parliamentarians, they were demanding many, many things. So from Magna Carta, the journey started from Magna Carta, and what is happening in the 17th century, that the king was forced to abdicate the throne. William III, or the William of Orange, and his wife Mary II ascended the throne in 1689, you know, when James II abdicated the throne. So, the William of Orange and Mary II accepted the demands of the parliament, and the parliament passed the Bill of Rights in 1689. The Bill of Rights is again a significant document. It was called, Glorious Revolution, as you know, it was called glorious. Why? Because it was a bloodless revolution. So the English Bill of Rights, what happened in the English Bill of Rights? It established a constitutional monarchy in England, as it limited the power of the king and granted protection to English subjects. So it is the beginning of the constitutional monarchy. From absolute monarchy to constitutional monarchy, from absolute power to limited power to the king. So, is it not a great development that we should try to ponder over? It also protected certain parliament's rights, the rights of parliament, like the right to freedom of speech and expression, the right to petition the king, and the right to regular elections. So, if these rights were emphasized, in this English Bill of Rights, so we can say it is the beginning of parliamentary democracy. It is the beginning of the constitutional monarchy. It also provided rights to all English subjects, trial by jury, and habeas corpus, to have body. Habeas corpus, that is one of the most important rights that we have got today. In our constitution, also under Article 32, we will find that habeas corpus has been mentioned. So, this is the beginning of habeas corpus from England. After that, you will find that putting further curb on the arbitrary powers of the king to levy taxes without the consent of the parliament. This English Bill of Rights also put curb on the arbitrary powers of the king to levy taxes without the consent of the parliament. So now, if king, it could not be arbitrary, because it was leading to exploitation of the peasants and the, of course, landlords as well. So that is why you see now the king could not levy taxes without the consent of the parliament. The king was also debarred from maintaining a standing army in peacetime without parliamentary consent. James II basically wanted to maintain a regular standing army even during peacetime. And that's why the people were apprehensive that he was going to threaten the rights of the people, especially the parliament. So that is why they were quite suspicious that why king was trying to maintain this regular standing army in peacetime. So, at that time, feudal lords used to bring their armies and they used to fight under the banner of the king against the foreign invasion. So, that was most of the time the principle of fighting, the principle of war. But now, king was maintaining, he wanted to, make England strong, and that is why he wanted to maintain a regular army. So, that why people were suspicious of this. Now, what is happening? They are forcing the king not to maintain a standing army in peacetime without parliamentary consent. The Glorious Revolution is also criticized by scholars, as they say it was neither glorious nor a revolution. So, like Magna Carta, you'll find that the Glorious Revolution is also criticized by many scholars. They say that it was neither glorious nor revolution, because it did not bring that kind of significant or meaningful change that you could say that it was a revolution. Nevertheless, the significance of Glorious Revolution cannot be denied, as it led to the establishment of a constitutional monarchy, that is the first achievement, a parliamentary democracy, and recognition of the rights of the subjects. The beginning of the parliamentary democracy is there from here. So, you know, uh, in some form, not the parliamentary democracy that we have today. It was not established here, but you will find this is the beginning. From here, the parliamentary democracy started taking a shape. great philosopher and who is also regarded as the father of natural rights theory. John Locke was the product of the Glorious Revolution. We should remember, you know, the normative justification for the rights as natural, that we have today, and when rights are considered as natural, it means you'll find when we say the rights are natural, during Glorious Revolution, what was emphasized? And John Locke was the product of Glorious Revolution, so that is why he believed that human beings are rational. They are endowed with reason, and they are quite capable of governing themselves. So that is why their absolute power should not be given to the government or the state to regulate the behavior of the people. And he said that there are three rights, and these rights are natural rights. Number one was right to life, right to liberty, and right to estate or property, according to him. These three rights were existing even before the existence of the state. So when he developed the social contract theory, and in his social contract theory, the great English philosopher John Locke says that a state, the people enter into the social contract to create a, government or a state for what? For preservation of those natural rights which were available to them even before the existence of the state. That was in the state of nature, according to him. And he says that these rights are right to life, right to liberty, and right to property. They must be respected by the state. A state cannot infringe upon these rights. So that's why, this is being emphasized by John Locke. Why? Because he was the product of Glorious Revolution. Otherwise, Thomas Hobbes, who was the product of Civil War of England, he says that natural rights were the main problem in the state of nature, which had made the state of nature, what is called the life of man in the state of nature was solitary, nasty, poor, brutish, and short, according to Thomas Hobbes. While John Locke is saying that the state of nature was a state of mutual goodwill, peace, and all. And that's why, just to make that peace permanent, and that to preserve the natural rights that were available to the people in the state of nature, they enter into a contract and created a state. So, in this lecture, we are trying to conclude over here. Thank you very much, learners. We are going to take up this issue. We will continue in the next lecture. Thank you very much.